Assalamu alaikum wa rahmatullahi wa barakatuh. Good evening and welcome to the special focus. My name is Zahid Jadid and we are indeed together until 8 p.m. yet once again on Salam Media. So we've got just under an hour to go, and so let's make the most of it. Of course, our topic this evening, we are discussing the legal matters around the coronavirus lockdown that has been implemented since the 26th of March. It's been quite a while at least. So this is in light of last week's judgment by the North Gauteng High Court, which declared the lockdown unconstitutional and invalid. So tonight, basically, what we are going to do is we are trying to get some expert analysis on this topic. And so let's dive straight into it. You know how to interact with us on Twitter. You can tweet and tag us. You can tweet at Salam Media, or you can tag rather my personal account, that's at Zahid. You can also send us a message via WhatsApp to 0617660355. Let me just repeat that. The number for your WhatsApp messages is 0617660355. Facebook comments also welcome, YouTube as well. And if you wouldn't necessarily like to comment or pose a question to our guests, then you can at least send us a thumbs up or any emoji of your liking, just to let us know that you are listening to the show, and that we do hope that you stick around with us throughout the show. So without further ado, let me now introduce you to our panel for tonight. Firstly, we have Dr. Kathy Powell, who is an associate professor in public law at the University of Cape Town. Welcome, Kathy, and welcome to the show. Thank you for joining us.
Thank you very much. Good to join you.
Indeed. We also have Aslam Musaji, who is a constitutional law expert, and he's an executive in ENS Africa's Dispute Resolution Department. Welcome to the show. Assalamu alaikum wa rahmatullahi wa barakatuh.
Wa alaikum salam.
Aslam, can you hear us?
Yes, I can. Can you hear me, Zahid?
Yes, I can hear you now. Welcome to the show and thank you for joining us.
It's my pleasure. Thank you for having us.
And lastly, let me also welcome Mr. Mike Lowe, who is a senior researcher at the Paternoster Group. Welcome to the show, Mike.
Hello, Zahid. Thank you very much for having me, and good evening to your viewers.
All right, awesome. It's indeed a pleasure to have all of you on the show. Now, Kathy, let's start with you. Firstly, from a legal perspective, how well has government struck a balance between being tough enough to combat the virus, whilst at the same time not trampling over the principles of democracy in its response to the COVID-19 pandemic? Kathy?
I'm not sure that's an accurate way of describing the two sets of the scale, the two balancing points, in that the government's been very tough when we've had people killed. But whether it's tough enough to curb the virus is a different matter entirely. So it has been very tough, very brutal. Some of its measures have helped to curb the virus because they've prevented contagion, a person-to-person infection. It seems not to have been that effective in setting up extra hospital beds, actually providing for the surge that they're expecting in coronavirus cases later on. So on the effectiveness side, where they've been most effective, where they've had the most to do, is where they didn't have to be tough in the first place. They just had to work on the hospitals and work on infrastructure and so on, or also provide water and sanitation and that kind of help to the poorer community. As far as the other side of the scale is concerned, you know, the balancing rights, I don't think it has done that very well. It certainly has not properly respected the right to life, the right to dignity, freedom of movement. And I think it has made a poor job of defending its choices in that regard.
Okay, so thank you for that, Kathy. Mr. Musaji, let me now bring you in to get your thoughts on this very same question. Do you think that government has struck a balance between being tough enough to combat the virus and at the same time not trampling over the principles of democracy?
I think we got to recognize that we're all dealing with a novel scenario And so hindsight is a perfect science. And I think we all will agree that government could certainly have done a number of things a little better than they have actually done. But whether that means that we need to be as critical of government as some of the commentators have been, I'm not entirely convinced. I think we're dealing with a very difficult situation. We're dealing with a scenario where a lot of this is unprecedented. We also, when you look at the international experiences and you look at the rate of infections and the level of increase in the infection rates in South Africa, I think from that particular perspective, the initial very hard lockdown has had a decent effect. But we're now beginning to see the significant spike in the infections. And unfortunately, that's a factor of having to balance people's ability to earn an income, for the economy to properly function, and at the same time try to protect lives and protect the poor and the more vulnerable sectors of our communities.
So, Kathy, just a question before I move on to Mr. Mike, who is, in fact, one of the panelists on this discussion as well. Kathy, just a question for you quickly. What happens to a society when civil liberties, rather, are curtailed, even for the slightest amount of time? Does it concern you at all? Because I do recall, actually, it was around the first week of the lockdown. I was speaking to another panel, and one of the concerns which were raised by one of the panelists that day was that we are in fact infringing on the civil liberties which have been guaranteed to us by the Constitution, and we'll get into this discussion deeper. So, does this concern you at all?
Yes, it concerns me very much. A crisis is a stepping stone to more autocratic behavior by the government. So I think some of this was already there. I think under the Zuma years, the executive was not being properly overseen by Parliament. And when Parliament did try, the executive responded with some contempt. So the executive already showed signs that it thought itself above the law and not accountable to Parliament. When you get a crisis, be it terrorism, be it the coronavirus, then the executive can say, oh, now we can do everything we want because we're fighting this huge crisis. And in fact, that was part of the defense in the judgment last week was, well, it doesn't matter if we are limiting rights because we are trying to limit the virus. That is very dangerous because it opens the door to a permanent, a long-term dictatorship or autocracy where the democratic rights and the people are lost. The rights of the people to govern themselves are lost.
And just before we move on, do you see such a situation unfolding in this case of South Africa? You're speaking about the lockdown perhaps paving a way for an autocratic government. Do you see such a situation unfolding here in South Africa?
I think we're at a pivotal point because there are these court cases and the regulations are being overturned and the government is having to account for itself and there is public outrage. I mean, it shouldn't take the death of a person to lead to this point, but I think these kinds of events, the brutality, the effect that the regulations are having are starting to lead to a groundswell that and the courts, I think, are making the executive feel the pressure. But I'd be interested in Mike Law's opinion on this, where this might be going. I'm glad of the courts, but I'm not sure where we're going at this point.
Okay, and that's in fact where I want to bring in Mr. Mike Law into this discussion, who is a senior researcher at the Paternoster Group. Mr. Mike Law, thank you for joining us. Once again, welcome to you. Now, as Kathy was saying, we are now seeing this matter going to the courts as people are realizing the situation. So all of a sudden, well, it seemed well all along. There was criticism at least, but it was just talk at the time. Now we see last week Tuesday, the North Gauteng High Court did in fact declare the lockdown regulations for alert level 3 and 4 as unconstitutional and invalid. So what do you make of this ruling, in fact?
Yes, I don't think any of us were surprised to see a judgment delivered against government on the rationality of some of the lockdown measures. It's natural that in cases where you altering the entire regulatory framework of the way that we do business and move almost on a monthly basis, that you're going to get anomalies and irregularities. So I don't think that was surprising. We knew that some of the measures were contestable. But what was surprising to me is the extent to which a court was willing to go in making that declaration. I think it's, as I said, it's obvious that some of the measures needed to be evaluated and scrutinized. But how the court got from that to declaring the entire set of level 3 and level 4 regulations invalid is quite a jump. And the court started off reasonably well. I thought it was a strange judgment, to be honest, in some of the ways it was worded and delivered. But I thought the court started off very sensibly by acknowledging how difficult this situation is. As Aslam, I would say, correctly pointed out at the start, this is a completely novel situation, and the way that the government acted early and in line with various health experts, and including the WHO, was applauded, and the court acknowledged that. But the test for rationality in constitutional law is a very stringent one. And when it got to applying that test to each individual regulations, it followed a very loose approach and made very sort of swift conclusions on the irrationality of some regulations, which I don't think you can really argue with on those ones that were listed. But to went from there to declaring the whole framework invalid, and that is difficult for me. And I think a little bit worrying because, as we say, it's pretty hard to argue that a hard lockdown followed by a gradual phased exit is completely irrational. It might be a different way that you or someone else would like to do it, but that's not the test for rationality. So I think it's great that we have an independent court system, that litigants can go to court and challenge government measures, and a court can rule against government. That's a luxury that we take for granted somewhat, as these courts have shown over and over again through the 10 wasted years of the Zuma administration. I think that's very positive. But when a court starts to step into the shoes of government and start substituting decisions, its decisions for the governments, that becomes a much more difficult terrain.
Okay, so before we move on, let's just get this straight. I know the judgment which was delivered last week Tuesday. It was met with much. It was met with a warm welcome by the public, but you, however, find that for certain reasons, which you did indicate in your response previously to the previous question, it was to a certain extent flawed.
Yeah, look, I think the public, it's natural that the public would applaud that judgment because it's a time where there's growing public unrest and frustration, which is natural in any country in this type of environment. But I wouldn't say that it was unanimously accepted. In fact, of the legal experts that I've spoken to and consulted and listened to, it's been almost unanimously rejected. So you can, yeah. I thought, you get guys like Dennis Davis, Peter Foss. I heard some great interviews with Tuli Madonsela, a former public protector, and I think everyone in the legal fraternity has these sort of mixed feelings towards this judgment.
Okay, now I just want to get some comment from you, Mr. Aslam Musaji. Do you think that government was prepared for this kind of judgment, particularly because it was against the government? Do you think they were prepared for it, or did they actually just take it as a pinch of salt? Did they perhaps feel that it might just be overlooked and dismissed, the actual court case? Did they really take this case seriously, Mr. Musaji? Mr. Musaji?
Yes, Zaid, I was surprised with the way government dealt with the particular application. I think there may have been some complacency that creeped in, particularly because there were a number of wins for government in relation to challenges to regulations prior to this particular application. And the examples that I have in mind there, where there was somebody that was hoping to attend the funeral of his grandfather in the Eastern Cape, and that particular application had been dismissed. There was then the Moss case, which I'm sure you know a lot about, where the government also succeeded and the court found that the regulations that had been put in place during the initial phase of the lockdown were reasonably justifiable and did not constitute an unjustifiable limitation on the rights to freedom of religion and freedom of movement and freedom of association. In addition to that, a challenge by the Solidarity against the Minister of Tourism, because one of the criteria for deciding how certain funds that had been put in place to help people in the tourism industry would be made available, and he was one of the factors that was going to be taken into account. And that particular challenge on the part of the Solidarity was also unsuccessful. So having had a spate of wins in the courts, they then ended up with this particular application, and I'm not convinced, just reading the particular judgment in question, that government did a good enough job in trying to justify some of the regulations that were in place. Having said that, I'm still not convinced that the judgment will survive on appeal. The court, I think, set out the correct test in regard to rationality, but I then think applied the test incorrectly. There's also an issue relating to mootness, which I think could have been argued. And on that particular score, you will recall that when this particular application had been launched, we were still under lockdown alert level 4. And therefore, the challenge on the papers related to the regulations that applied during lockdown alert level 4. The application was then argued on the 28th of May, which was the same day that government announced the regulations for alert level 3 that were due to come into effect 1st of June. And the judgment was then delivered on the 2nd of June after the regulations for alert level 3 had come into effect already. So, you know, the need then to declare unconstitutional the regulations for alert level 4 fell away because those regulations were no longer in place. And there wasn't a direct attack to alert level 3 regulations on the papers because that wasn't before the court at the time. And therefore, I think it was improper in the circumstances for the court to have declared that both alert level 3 and alert level 4 regulations are unconstitutional. In addition to that, the difficulty I found with the judgment is that while the court dealt with particular parts of the regulations, the court often decided whether or not a part of a regulation was irrational with reference to what was permitted by other regulations. And let me give you a concrete example of that. The court said, for example, it was irrational not to allow people to visit their ailing loved ones in circumstances where you were allowing 50 people to attend a funeral. But the fact that you allow 50 people to attend a funeral doesn't necessarily mean it becomes rational automatically that people should be allowed to visit the sick. It may very well be that it's irrational to allow as many as 50 people to attend a funeral when you have the crisis of the pandemic on the go. So I do think also that it was incorrect for the court to have done the analysis of rationality with reference to what's permitted and what's not permitted under the regulations.
And I do, in fact, want to pick up on the government's response to this judgment. They are, in fact, appealing this judgment. And I do want to also speak about the fact that the invalidity has been suspended for a period of 14 days, the declaration rather of that invalidity. I also want to speak about the independence of South Africa's judicial system, but all of that is coming up after an ad break. We need to take an ad break now quickly, and when we get back, we will unpack those issues. Please do stay tuned.
Virus. The World Health Organization has declared the coronavirus outbreak as a global pandemic. Penny Appeal believes in prevention being the cure, and we remain firm in standing by our commitment to support and help those in need.
Because the border have closed, so are very, very affected. So
they are lacking in the supplies.
I hope government can find a solution.
Our response is to provide hardship grants to those experiencing a loss in income in the months to come, and hygiene kits for the vulnerable at home here in South Africa and Syria and Palestine. Show compassion in the midst of crisis. Donate to our coronavirus emergency appeal now. Be proactive. Be aware. Help save a life. Donate today. Call 031 11 00573 or donate via www.pennyappeal.org.za. Penny Appeal. Small change, big difference.
With over 80 years of experience, IG Hussein and Company are renowned for their quality Islamic wear and goods. IG Hussein and Company stock a variety of Islamic items, musallas, kitabs, Medina dates, perfumes and exclusive gifts. We guarantee you a unique and friendly shopping experience for the entire family. Visit our new branch in Overport at 202 Kenilworth Park, Brickfield Road. Open 7 days a week with ample parking and wheelchair friendly. Like us on Facebook or Instagram at IG Hussein for our latest promotions and updates. IG Hussein and Company, your Islamic lifestyle. With over 80 years of experience, IG Hussein and Company are renowned for their quality Islamic wear and goods. IG Hussein and Company stock a variety of Islamic items, musallas, kitabs, Medina dates, perfumes and exclusive gifts. We guarantee you a unique and friendly shopping experience for the entire family. Visit our new branch in Overport at 202 Kenilworth Park, Brickfield Road. Open 7 days a week with ample parking and wheelchair friendly. Like us on Facebook or Instagram at IG Hussein for our latest promotions and updates. IG Hussein and Company, your Islamic lifestyle. Listen to something fresh. Listen to Salam Media, your humanitarian broadcaster.
And welcome back. It is 24 minutes past 7 p.m. and this is the special focus with myself, Zahi Jadwat. This evening, we are discussing the legal matters around South Africa's coronavirus lockdown. My guests tonight are Dr. Kathy Powell, who is an associate professor in public law at the University of Cape Town. We also have Mr. Aslam Musaji, who is a constitutional law expert and an executive in ENS Africa's Dispute Resolution Department. We also have Mr. Mike Law, who is a senior researcher at the Paternoster Group. Welcome back to all of you, and thank you for joining us. Now, just before the break, we were discussing the North Gauteng High Court's judgment against the coronavirus lockdown. The judge there, Judge Norman Davis, has in fact declared the alert level regulations for alert level 3 and 4 as unconstitutional and invalid. Kathy Powell has just indicated to me that she would like to respond and pick up on what the other guests, Mr. Musaji and Mr. Low, had said just shortly before we took the break. Kathy, please do keep it as brief as possible because we do have quite a few other topics which we'd like to touch on. So go ahead.
Oh, all right. Well, let me not hold up the broadcast then. I agree with what both Mike and Aslam said about rationality. I think it is true that the judge gave one test for rationality, and that it's not that he applied another, he just didn't seem to apply any. The example of the funeral versus the bedside, if you were to do a rationality test there, you'd have to find whether there's a legitimate government objective, and the only one the government suggested was curbing infection. And you would find that keeping people away from a COVID-ill person is has a rational connection to that legitimate government connection. Whereas people attending a funeral where nobody might be ill is different. But I also found it alarming that the rationality of one regulation was determined by reference to another. Bear in mind that on occasion the judge gave no reason at all for declaring something rational or irrational. But actually, I wanted to pick up on points that both of the other speakers made. You asked me, is it bad if the executive is going beyond its powers or abusing its powers? And what it boils down to is that the rule of law requires a relationship of respect between the government and the citizens of the country. If that is lost, and it requires also that every organ is complying with the law. Now, the problem with the judgment we were discussing is that the judge himself did not properly comply with the law. And the problem with what the executive is doing is that the relationship of trust is being lost between the people and the executive, and that can lead to long-term damage, because if people don't trust government, they don't work with government. That's it.
Interesting point there, that if people don't trust government, they don't work with government. That's a very interesting point. Now, I want to touch on the competence of our judicial system, our judiciary, and its independence. So, on one hand, one might suggest that last week's ruling is an indication that our judicial system is alive and kicking. At the same time, though, as we have analyzed and our guests have pointed out, there might be certain flaws in the judgment itself. What do you make of the judicial system in South Africa, Kathy?
Well, I think it is fairly independent, and I think independence includes the power to get something wrong. If you can't get it wrong, then you're not really in a separate category from the other branches of government. The independence of the judiciary will be protected if that ruling goes on appeal and is overturned with good legal reasoning. So I'm not worried that one single judgment means that the judiciary is not independent. I do think it needs to be corrected, but it can. The independence of the judiciary is at risk when the government starts to show it contempt. And picking up from what Aslam said, it may be that the government was complacent about that judgment and not bothering to bring its arguments in properly. But notice that judgment happened shortly after the Collins Causa judgment. And in that as well, the judge remarked that particularly the police and the SANDF had simply not bothered to defend themselves against the application. The same thing seemed to happen here. I know that there's currently a case being brought against the very organ of the NCCC at the moment, and the government did not get its papers in time. So that kind of thing, where the court's working is actually being undermined, that's a problem for the independence of the judiciary. And of course, then if they don't comply, if the government doesn't comply, that's a problem. But it has, I must say, it's lodged an appeal, which is the correct process. And let's hope they keep complying with court decisions.
And Mr. Musaji, we are aware that the government has decided to appeal this judgment. So what, in your opinion, are the prospects for this appeal? Will last week's judgment survive the scrutiny of a higher court, perhaps?
For reasons that I articulated earlier, I'd be very surprised if the judgment is upheld by an appeal court. I think there's a strong possibility that an appeal court will overturn Judge Davis's judgment.
And so I just see a comment which is coming through here from Mohammed. He's actually asking a question. So basically he's asking, could the ANC have any influence over the court? And he quotes the Constitution, wherein it states that the Chief Justice of the Supreme Court shall be appointed by the President. Do you think that we should fear any such occurrence, considering that we do have a fairly just independent system? Independent justice system, rather. Yeah.
I have no concerns about the independence of our judiciary. I think we have a robust, independent judiciary. From time to time, judges do get things wrong. But we also have to put things in proper context. This was an application with a voluminous set of papers. It was argued on a Thursday. The judgment was delivered by the Tuesday of the next week. And ultimately, a human being had to deliver the judgment. And as humans, we all make mistakes. So I don't think we need to be too harsh on a judge. That's exactly why our legal system has protections in place, which allows for appeals to a higher court where, either a Supreme Court of Appeal with 5 judges or a constitutional court with 11 judges will consider the merits of a particular judgment. And, the fact that our Chief Justice is appointed by the President or a number of judges are appointed by the President after recommendations from the Judicial Services Commission is of no concern to me, because we've already seen judgments being delivered, for example, by the Constitutional Court against former President Zuma, despite the fact that President Zuma had appointed Chief Justice Mogoeng as the Chief Justice in the country. I think he's impressed all of us, and he's done an incredible job, and so has a number of other members of our judiciary.
Okay, and just a point which has been mentioned by Kathy, she's just indicated here off air. There is perhaps a possibility that the appeal court could find the regulations irrational in a fresh analysis. What do you think of this, Mr. Musaji? Kathy, rather. That's what you think. Do you really think that this might happen regarding the appeal by government to the judgment which took place last week?
Technically, it's possible because it's an appeal, it's not a review. So the appeal court is not just going to examine the decision-making process of the quota quo, the first court. It's going to actually look at the legal analysis as well. The problem is, and Aslam did alert us to this, that the actual case was against the level 4 regulations. And the appeal court might decide there's no point in working out whether the level 4 regulations are rational or irrational. On the other hand, the issue is not moot for level 4 because it's been made clear that we might go back to level 4. So it is possible that an appeal court will overturn the High Court's ruling, but then itself examine the regulations, I think only of level 4, not of level 3, because level 3 should not have been pronounced on, and could, in a fresh analysis, find that there's no rational connection between the regulation and a legitimate government objective. So we could end up finding that some of those regulations are irrational. And even if it's not the current ruling regime, I think that's going to make a difference to the government and to the public.
Okay, we just have about 25 minutes remaining of this discussion. Before I get to you, Mike Law, I think Mr. Aslam Musaji does want to, in fact, respond to what Kathy just had to say. Mr. Musaji, sweet and short, please.
Sure. I've had the benefit of seeing the underlying papers which gave rise to Judge Davis's judgment. And the attack was not so much on the rationality of the regulations. The primary attack was whether or not government could act under the National or the Disaster Management Act, or whether they acted unconstitutionally and in fact should have declared a state of emergency, which would have given rise to other safeguards in terms of the Constitution. There was also an attack in regard to whether government could make regulations about gatherings by virtue of what is contained in the Gatherings Act. All of those attacks did not find favor with Judge Davis. So I'm not overly optimistic that on the basis of the way the applicants in this case had pleaded the case, that there's a good possibility that a court, even if it disagrees with Judge Davis and finds that he applied an incorrect test or didn't apply any test appropriately, I'm not convinced that on a fresh analysis, on the basis of what had been pleaded before the lower court, there's a strong possibility that a court will find that the alert level 4 regulations were unconstitutional.
Okay, so whether or not this judgment is upheld, the fact remains that perhaps the regulations of alert level 3 and alert level 4 are in fact unconstitutional. And as we all know that regulations for alert level 5 were much stricter and curbed, they infringed much more on civil liberties and personal civil liberties. Mr. Mike Law, I hope you are still with us. So let me bring you in to respond to that. What does this particular judgment against the regulations for level 3 and 4, what does it mean specifically for level 5 regulations? Because there is a possibility that remains throughout, that we might return to level 5 regulations as well in certain instances in parts of the country wherever necessary, as has been indicated by the president. So what does this particular judgment mean for level 5 regulations?
Yeah, I think the answer to that one is that the judgment doesn't make a ruling on level 5. It remains on the statute books or in the regulations. And yeah, it doesn't really change anything with level 5. As you say, it's a bit of an anomaly. If the judge was willing to declare level 3 and level 4 irrational, that these level 5 regulations, which are much more stringent, were left alone. That is a bit of an anomaly in the judgment, but yeah, it doesn't affect level 5. As you say, there's a chance that we might go back to level 5, as we might go back to level 4, which is why I agree with Kathy that it's not necessarily moot. Yeah, I think, but there's an acknowledgement from the judge, and I think from various stakeholders, that the level 5 lockdown was necessary, was what we needed to do hard and early. I think even the opposition political sphere agreed with the initial 3 weeks of the hard lockdown. So I think there's almost sort of unanimous understanding of that was justified. Whether we go back there, the government doesn't want that to happen. I don't think anyone wants that to happen. It is a possibility, especially at a local level. I think the chances of the whole country being moved to level 5 are very remote, but the risk-adjusted strategy correctly makes provision for different levels to be in place in different areas at different times. And yes, there's a possibility that level 5 will return in some areas, but and yeah, that would form substance, part of the substance of the ruling, and so it will be left alone.
And now I guess time will tell whether the judgment from last week is upheld, pending the appeal by the government relating to this judgment. But as things stand, as declared by the court, the regulations are unconstitutional. So what do you think about this? The fact that our democratic government has in fact enforced an unconstitutional set of regulations in a democracy. Mike?
Look, I wouldn't overreact to that. I think it's, as I said earlier, when you are changing entire regulatory frameworks for doing business, moving all sorts of aspects of our lives in any country, and it's not just South Africa, some anomalies are going to arise in the regulations. And it's important, A, that people can approach a court, and B, that the government thinks about it and goes back and fixes these anomalies when they arise. But I wouldn't read too much into saying, oh, well, they've imposed an unconstitutional framework on us, and therefore the government is a complete bunch of idiots. I don't think that's true by any means. In fact, the risk-adjusted strategy and the initial approach, the broad framework for the government's thinking is very sound, in my opinion. And the court acknowledges is that if you read through the regulations, at the top, they kind of have the risk-adjusted strategy in sort of a legal text and how the decision is made to move between alert levels, and that isn't touched in the judgment. It's only the technicalities of level 3 and level 4. So it's disconcerting that the government has imposed some things that are probably a bit irrational, and definitely it's concerning that the heavy-handed approach they've taken in implementation. And as both panelists have spoken to, the relationship of trust between the government and the citizens, and the chances of getting voluntary compliance, that's what's worrying. But yeah, I'm not throwing my toys out about this judgment and particularly what it means for the government's approach.
So you wouldn't exactly overreact to the situation. Kathy, I just want your thoughts on this quickly before we move on. Your thoughts regarding the fact that government has in fact enforced a set of unconstitutional regulations.
It's also not a disaster that it has done so. Just as courts can make mistakes, governments can make mistakes. So I also don't think it's the end of the world that it did so. Remember that its use of the underlying legislation, the Disaster Management Act, and its declaration of a state of national disaster were all accepted as constitutional. It was simply the specific regulations that were then issued under the authority of this act that were found to be irrational. Government does irrational things all the time. If they're properly challenged in court and overturned, then they stop. I think the problem we're facing here is that it's a more multifaceted problem than just individual small irrational acts. What the various challenges seem to draw to is the lack of a central plan, maybe a coherent plan that is not just trying to curb the virus, but also trying to save a whole lot of other issues like people's livelihoods, economic factors, people's survival, and so on, mental health. It's not a disaster that they've been declared irrational, but it will be a disaster if they don't respond well. And on that point, by the way, you said, what does this judgment mean for level 5? I think, firstly, that it's very hard to apply this judgment to any other judgment because there's so little reasoning to transfer. But given that the judge was so keen on rejecting one regulation because another regulation was less strict, level 5 will actually probably pass muster under this judgment because all the regulations are terribly strict. So the judge can't say, hey, it's not fair that somebody can't do hairdressing, but she's watching all these full taxis go past because you can't do hairdressing and there were no full taxis. So I think if that is the reasoning, which is not the correct reasoning, but if that's what we're going to apply to level 5 will be fine. But as I think all of the panelists are saying, the reasoning was incorrect.
Indeed. And for the listeners, remember that you can, in fact, engage with us. You can engage with the panelists for this evening as well. I see Mohammed Azhar Bulbulia is also listening to the show. Faye Khan is also listening to the show. Thank you for tuning in. Let's take an ad break now. We'll try and keep it as short as possible. And when we get back, there's still much more to discuss, but we'll try to wrap up. Please do stay tuned.
COVID-19 has been declared a global pandemic, and South Africa has called a national lockdown to curb its spread. At this difficult time, the Al-Imdad Foundation is assisting informal traders who lose their livelihoods, the homeless, the elderly, and those who are most vulnerable in South Africa and internationally. Let's fight this crisis together. Donate online at alimdad.com or call 0861 786 243 for more information.
Osman's Taj Mahal Spice and Rice. For over 80 years, Osman's Taj Mahal have been perfecting the art of the perfect blend of spices, pure, aromatic, and well-seasoned. Spices to tantalize your taste buds. From creative cuisines to gastronomical gourmet goodies. From exotic odors to traditional dishes, Osman's Taj Mahal have remained synonymous with quality spices and condiments. Taj Mahal rice, beans, and lentils. Try our range of chili bite mixes, rose and ilachi syrup, our quick and easy biryani pack, and our traditional range of spice blends. Osman's Taj Mahal. There is no substitute for quality.
Never before has humanity faced a pandemic like the COVID-19 virus.
The World Health Organization has declared the coronavirus outbreak as a global pandemic.
Penny Appeal believes in prevention being the cure, and we remain firm in standing by our commitment to support and help those in need.
Because the border have closed, so are very, very affected. So
they are lacking in the supplies.
I hope government can find a solution.
Our response is to provide hardship grants to those experiencing a loss in income in the months to come, and hygiene kits for the vulnerable at home here in South Africa and Syria and Palestine. Show compassion in the midst of crisis. Donate to our coronavirus emergency appeal now. Be proactive. Be aware. Help save a life. Donate today. Call 031 11 00 573 or donate via www.pennyappeal.org.za. Penny Appeal. Small change, big difference.
Listen to something fresh. Listen to Salam Media.
And welcome back. My name is Zahi Jadwit. This is the special focus, and tonight we are discussing the legal matters surrounding the lockdown. Let me just remind you, our guests for this evening, we have Dr. Kathy Powell, who is an associate professor in public law at the University of Cape Town. We have Mr. Aslam Musaji, who is a constitutional law expert and a director at ENS Africa. We also have Mr. Mike Law, who is a senior researcher at the Paternoster Group. Just looking at some of the comments which have been coming through, remember, for the listeners, you can send us your input. You can send us a WhatsApp text message to 061 766 0355. Alternatively, you can tweet and tag at Salam Media, or you can comment below on Facebook. Looking at some of the comments we have a comment from Louis Nell, which reads, "The annual sardine run is underway. Cars and people on the beach lugging out fish in hordes rather. How do you enforce an unconstitutional and irrational lockdown? The lockdown is over," he declares. Jonathan Constable also saying, "Following recent court judgments confirming the irrational and unconstitutional lockdown regulations, South Africa is now faced with the danger where government is preparing to either bluntly ignore this judgment or to delay the implementation of corrective measures. Prepare for it." And one from Anonymous, "Reduce your rights according to the Bill of Rights as instructed."
Your sound
Comments
is
which have come through, especially this one from Jonathan Constable. So this one about the is now faced with the implementation of corrective measures. Prepare for it. What do you think is now to come next? Will government actually adhere to these to this regulation to this judgment rather, or do you think they might just bluntly ignore it? Mike?
Sorry, Zahid, I didn't quite catch all of that. You're having some connection problems there. Maybe it's from my side. What will government do? Well, they've appealed the judgment. Yeah, so I think it would have been worthwhile for them to, even though I think all of us disagree with the judge's reasoning, and that the government was right to take it on appeal. It didn't stop the government from reading past the judgments and using it to go rethink some of their measures. And they could have complied with it, at least in part. So I think the government's taken the correct approach. But what it could do as well is just, use this judgment as a little bit of an indication that they need to be more transparent. They need to explain their rationale for their decisions better, both to the courts and to the public. And that they need to correct some of the anomalies in the regulations that are irrational. And they can do that while still appealing the judgment and still taking these important legal questions as to how you frame the test for rationality and to what degree of deference you give the executive at a time of national disaster. These are important questions that should get to the Constitutional Court, quite frankly, even though they've appealed to the SCA. The Jackson Mthembu, the minister in the presidency, initially indicated that they would appeal to the full bench of the High Court. I would have liked them to have appealed directly to the Constitutional Court because I think it's important that this gets before the Con Court as quickly as possible. So the matter will now go to the Supreme Court of Appeal. That was confirmed today. And yeah, so I don't think the government should completely lose heart with what it's doing. I think, as Aslam pointed out earlier, that they've done a really good job with the infections and the amount of deaths if you compare it to other countries that have far more resources than us. So I don't think they should let this judgment beat them up. Yeah, they need to tinker their approach and keep doing what they're doing.
And of course, this judgment did come from a separate application in a separate court, Mr. Musaji. You would recall that last month, the Democratic Alliance said that the national lockdown under the Disaster Management Act, the DMA, is unconstitutional, and they called for the legislation to be amended to give the National Assembly more oversight powers. Now, the party is taking the government to the Constitutional Court in two separate matters, which challenge the validity of some aspects of the lockdown. So the question is, how does last week's North Gauteng High Court ruling affect their application, rather, and what are the prospects for this application which is being made by the Democratic Alliance? Aslam?
I think last week's judgment has no bearing on the DA's application for direct access to the Constitutional Court, in which it's trying to declare Section 27 of the Disaster Management Act, which gives the Minister Dlamini Zuma the ability to declare the state of national disaster and then to issue regulations and directions pursuant to that declaration. I think those are two separate issues. I think the DA's application is a very interesting application. Usually the Constitutional Court grants direct access in exceptional cases, but I do think the DA has raised some very interesting arguments about us being in unprecedented times, which does call for a pretty urgent determination of whether or not the provisions of the Disaster Management Act are constitutional in circumstances where the minister can get a national state of disaster and issue the regulations and the directions without any parliamentary oversight. Having said all of that, I'm not convinced that the DA's application is a slam dunk application for various reasons. The first challenge that the DA is going to have is that when the Disaster Management Act had been enacted, the DA had supported the enactment of the Disaster Management Act. So questions are going to be asked now, why is the DA complaining when they supported the enactment at that particular stage? The second issue that the DA is going to have to grapple with is the fact that you have a scenario where you have the regulations that have been in place for 2 months already, and only after 2 months the DA instituted this particular application for direct access to the Constitutional Court. And government is using that to suggest, well, the DA didn't have serious concerns and this is really an attempt to try to score political points. And then the further issue that the DA is going to have to grapple with is government says in any event there has been oversight by Parliament because there has been accounting to Parliament about the measures that have taken place. And that's a matter of opinion. I think if you talk to the ANC, they'll suggest to you that there is sufficient oversight. And if you talk to some of the opposition parties, they'll say to you there hasn't been oversight. But I think the one thing we can't run away from is that there has been at least some level of consultation between the presidency and the opposition parties, particularly at the stage when we initially went into the full lockdown.
Okay, we have just about 6 minutes remaining before we end this discussion. Unfortunately, time is against us. Kathy, you might just want to pick up on what Mr. Musaji has had to say about the DA's application to the Constitution Court.
Yes, very briefly, I think it's important to note that ordinary legislation is allowing for untrammeled executive action at a rate that the Constitution itself does not. And although state of emergency might seem to be different because it allows rights to actually be derogated from, not just limited, in actual fact, the way the executive is working is as though we had a state of emergency, but minus all of the extra parliamentary processes that are built into Section 37 of the Constitution to make sure that a state of emergency does not lead to abuse by the executive. So I think comparing a state of emergency to the DMA and how it's being implemented is quite important.
Mm. Okay, Mike, we just have 5 minutes remaining of the show. Before we wrap up, I think we can wrap up on this question. So how much longer is the government allowed to continue with this disaster, the state of disaster? Legally speaking, how much longer can this actually continue?
That's... Sorry.
Mike?
Go for it, Kathy. Well, look, Kathy will. Let's give Kathy a say on this because she'll know the detailed rules.
Thank you, and sorry if I butted in. That's one of the other problems with the DMA. There is no limit on the number of extensions.
Yeah.
And there is no requirement that the minister actually give any reasons when making an extension for that extension. So we could be living theoretically under the DMA for the rest of our lives. Now, a state of emergency, you can't do that. And I disagree that the parliamentary processes, they've tried to exercise oversight, but in many cases, the executive has simply refused to cooperate with the oversight process. So they've refused to provide information like Dlamini Zuma on the smoking ban. The SANDF generals turned up and said, you're not our clients, we work for the president. So I don't think the oversight part is working, and I think the DMA is letting in too many dangerous possibilities.
Well, that's actually concerning, don't you think?
Yes.
That is concerning, yeah.
That is why these challenges are so important.
Okay. Unfortunately, I think that's where we'll have to leave it. But before we actually end this discussion, I just want to give you each about a minute each to give your parting shots on this discussion. You can start, Mr. Musaji.
I think it's important that we distinguish between poor regulations, poor implementation of regulations by law enforcement officials. I think there has certainly been overzealous conduct on the part of our law enforcement agencies, and I do think the President and the Minister of Police could have done a lot more to criticize them and hold them to account a lot sooner. So I think that's an important point. I think the second issue is a lot of people are making much of the fact that the Davis judge declared the regulations is unconstitutional. But now that there's an appeal pending, there's a suspension of Davis's order. And that means that for as long as the appeal takes to get heard, Davis's judgment is not properly in effect. And therefore, as things presently stand, the Alert Level 3 regulations are in place and we expect it to comply with it.
Mike, your parting shots for the listeners and viewers.
Yeah, my last comments would just be to urge patience and understanding. I think there's a lot of criticism being thrown at the government right now, that blame thrown at the government that really should be thrown at coronavirus. You hear things like the ANC lockdown crisis and the economic crisis caused by the ANC. Coronavirus is what caused these crises. And, I've been a fierce critic of the ANC government, this one and the previous one. But when it came to coronavirus, I think we need to give them a little bit more deference than a lot of the commentariats and the public are giving them now, and understand that this is really, really, really difficult and it's extremely high stakes game. And there are going to be mistakes made. No country has got it perfect. You look at the UK, the USA, Russia, some of the biggest, most resource countries in the world that are some of the most criticized governments on this. It is really tough, and we've got the big decisions right. When to lock down, how to lock down, how to exit, even if the timing might have been a bit contested. And so when a judgment, things come up like this, at the end of the day, the government is not going to be judged on 2 weeks without rotisserie chickens and slip-slops and walking on the beach. It's going to be judged on much broader issues. And we need to be patient and keep listening to the health advice and the regulations that we get, because it's going to be a long and difficult recovery.
And I'm hoping you have something for the listeners as well, Kathy. I'm sure you have quite a bit, but yeah, it's already 8 o'clock. Just your final thoughts, your final comments.
I will be disciplined. Thank you. Mike's points were very good. And in fact, one of my critiques of the judgment the De Beer judgment from the North Gauteng High Court was judicial overreach. One of his critiques of the ban on nighttime vigils is he said, well, if you want to prevent infection through nighttime vigils, then you can just regulate the nighttime vigils. First of all, that's not the rationality test. But secondly, he's actually stepping into a terrain which is not his own. He has to give the executive the proper level of deference there. So I would agree on that. But on the other hand, I think that the more we do to make sure that the law is actually governing this process, rather than a couple of whims that haven't been thought through, the better our chances are. I don't think the motivation of the DA or even its voting record in Parliament affects whether it is making a legally valid point now. And I think that, yes, let's be patient, let's abide by the rules in the meanwhile, but we've got to keep up a fight for the rule of law, because that can be lost very quickly.
Unfortunately, that's where we are going to have to leave it. It's already 1 minute past 8 o'clock, and I think the next the next show, the host of the next show, Shabnam, is really going to be upset with me about this. But anyway, there's lots of important discussions to be had. This is something that affects all of us as South Africans. Anyway, to the listeners, thank you for tuning in tonight. It's been an absolute pleasure to be hosting you this evening, and to the panelists as well. Thank you for joining us. It's been an absolute pleasure engaging with you. Thank you for your contributions. Anyway, that's it from me for now. Thanks to technical producer Sadiq Joseph. From myself and the team, Assalamu alaikum wa rahmatullahi wa barakatuh.
Thank you. Thank you.